Great. Well, hello and welcome to Decolonizing Justice, and welcome back to those of you that have joined us already today or this week. I'm Liz Keith. I'm the program director with Pro Bono Net, and we are delighted to be sharing this space with you today and for this week-long series of conversations on legal empowerment and community-based justice strategies in the U.S. For those of you that were with us this morning, our interpreters, Cooperativa Brujulas will rejoin us on Thursday for the opening keynote by Antoinette Carroll from Creative Reaction Lab called Living Justice. But before we begin today's session, I wanted to just go over a few housekeeping reminders and logistics, and also thank again the National Center for Access to Justice for designing our sessions for today, which are centered on the theme of democratizing the law, regulatory reform, and roles beyond lawyers. So before we begin, we again encourage everyone to participate in these conversations through the Zoom chat, the Q&A boxes, and also to use the event Slack space to continue these conversations. About 100 people have joined that space so far. And again, if you have any questions or concerns or need technical or accessibility support, we're here to help, and you can reach out to our event facilitator, Jenny Rose Halperin, at an address that we'll share here. I also wanted to thank my colleague from Pro Bono Net, Kathleen Klock, who is assisting with live note-taking during this session to help people follow along, and we'll share a note to that document through the chat box. So I'm delighted to now welcome and turn it over to Chris Albin-Lackey, the Legal and Policy Director for the National Center for Access to Justice, to introduce our next topic and panel Voices from Beyond the Legal Profession.
Thanks very much, and good afternoon, everyone. My name is Chris Albin-Lackey. I am the Legal and Policy Director at the National Center for Access to Justice at Fordham Law School. Those of you who were able to attend the earlier session today will have heard a very compelling and eloquent case about the need to open up new space for people other than JDs to use the law to help other people. You'll have heard a lot of compelling evidence that those approaches can work, and that indeed they represent part of any possible realistic solution to closing the access to justice gap in this country in a meaningful way. And yet, that kind of work is prohibited and in many states, in fact, criminalized across the country, in spite of some really promising efforts in some states to revisit those restrictions and open up new space. Now, I guess in the interest of full transparency, I definitely agree wholeheartedly with all of the views that were expressed on that first panel. But the point of this panel is not just to reinforce those messages with a different set of panelists. The point of this panel is to do something very different. What we really want to do here, through the really excellent and inspiring collection of people that we've been able to bring together, is to offer a really powerful illustration of just how much we are missing when we have these policy debates just among lawyers, without including voices from outside of the community of lawyers in this country. Since we're all here attending a conference on the theme of decolonizing the law, I think it's probably safe to assume that everyone in the audience would agree with the sentiment that the law does not belong to lawyers. And yet, the policy debates around the idea of re-regulating the profession of law, as rich and interesting and passionate as they can be, too often do end up being a debate among lawyers without a lot of other voices in the room. Why does it matter that we have a more inclusive kind of conversation than that around these issues? Because it's not just about the principle of inclusivity. It matters because the people who are confronting the day-to-day reality of unmet legal need in vulnerable communities around this country very often are themselves non-lawyers. The people who will be in the position to assume new roles that allow for new models of legal services delivery are by definition non-lawyers and often will have a better perspective than JDs on what kinds of roles are actually useful and what it would take to make them work. So with all of that in mind, we're really fortunate today to be able to bring forward 4 really smart, inspiring, and dedicated people who are working with very different populations and very different professional walks of life, but all of them are confronting in a very direct and personal way the larger crisis of unmet legal need in this country, and all of them are working under the shadow of rules that don't always allow a lot of possibility for it, to try and do work to help connect people or provide the help that people need and often struggle to get. So without further ado, I want to turn it over to our panelists. I'll just say a few brief words of introduction about each of them. Our first speaker is Rohan Pavuluri, who's the CEO and co-founder of Upsolve, which is a really exciting and innovative nonprofit that helps connect low-income people to free help filing for bankruptcy protection. Next up, we will have Sarah Bové, who practices law, essentially, family law, although not as an attorney, but as a limited licensed legal technician under a really innovative program that Washington State embraced several years ago, and which other states are now moving to emulate, along with other reforms. Next up will be Katie Stewart, who is the National Coordinator of Veterans Justice Outreach at the federal government's Department of Veterans Affairs. And then finally, we will hear from Michael Buono, who's the Head of Reference and Patron Services at Brentwood Public Library, which is a very busy public library here in New York, where a lot of patrons come in struggling to find help with various legal needs. So with that, I will stop. I'll turn it over to you, Rohan. I think we will try to allow each of our speakers to go through and deliver all of their remarks, about 10 minutes each. Please enter any questions that come up that you would like to put to them in the Q&A. I will keep track of them, and I think we should have plenty of time at the end to address hopefully all or at least most of the questions that the people in the audience might have. So with that, Rohan, please take it away.
Thank you so much, Chris, and thank you everyone for joining. My name is Rohan Pavuluri, and CEO of Upsolve. I thought I'd start by telling you the story of Upsolve and what we do and how we've been able to meet an unmet need within low-income Americans and working-class Americans who are suffering from severe financial distress. When I was an undergrad at Harvard, I started spending a lot of time at Harvard Law School at something called the Access to Justice Lab. And the Access to Justice Lab was working on these paper packets for people to solve their own legal problems when they couldn't afford lawyers. We were working on producing packets for people who had trouble accessing bankruptcy because they couldn't afford a bankruptcy lawyer, helping people who were sued for their debt and needed to respond to their debt collection lawsuits. And in the process of working on these packets, I was exposed to this huge problem in America that we all know about, which is that low-income families live under a different legal system than everybody else. When they can't afford lawyers, they can't access their rights. And this made me really, really angry. And I saw an analog to pre-civil rights movement America, where Black and brown communities had to pay poll taxes in order to vote. Our current status quo within the civil legal system is actually not so different. If you can't afford to pay a fee in order to access your legal rights, you can't afford those rights. And in many ways, the complexity of modern day legal forms that I was seeing, whether they were bankruptcy forms or other legal forms, were a lot like literacy tests. When you can't understand the legal forms, you can't access your rights. So these modern day literacy tests and poll taxes that I came to see for the first time made me really, really angry. And I wanted to find a way to scale the work of these paper packets, which I thought were actually really powerful. When we gave people these packets, we empowered them to solve their own legal problems. And to me, that was something really, really exciting. So I moved to Brooklyn in 2016. And with my co-founder, who's a bankruptcy lawyer, we opened up a bankruptcy clinic out of the Robin Hood Foundation's office in Brooklyn. or helping people one at a time. And as we were helping them, we came to a few realizations. Number one, and we started with bankruptcy because we saw that there were so many people in America who faced financial shocks from losing their job, medical illness, a divorce, and needed access to bankruptcy, which was this amazing legal tool to allow them to relieve their debt, re-enter the economy, but that it was impossible for them to access bankruptcy because they couldn't afford the $1,500 on average that was required. And it was sort of this cruel irony in America that it costs $1,500 in order to tell the court that you have no money. And moreover, there's this culture within the bankruptcy system that always pushes people to lawyers no matter how little money they have. And to me, that was an injustice when you had this institution telling people who, in many cases, obviously couldn't afford lawyers to go find lawyers. And if they couldn't find the lawyers, that they were out of luck accessing their civil legal right that was supposed to be guaranteed. So that's what led us to explore creating an alternative way of providing assistance. First, we opened up a basically brick and mortar legal aid clinic, helping people one at a time as they came into our office. And it was through this process that we actually really got to know the community we were trying to serve and realized that there was actually a way to create a software tool, a lot like TurboTax, to help people on their own go through the process of filing for Chapter 7 bankruptcy and getting a discharge. And what we realized is if we focused on people who didn't own expensive homes or didn't own homes at all, didn't own any expensive assets, we could actually empower them to use our tool to go through the process of filing for bankruptcy. So the way that Upsolve works is people come to our website today, they answer a series of questions about what they earn, spend, own, and owe. We make sure that they don't own a home or don't have a complicated situation, and then our software helps generate their forms that they can take to the court to file on their own. And over the process of the last 3 years, we've been able to grow Upsolve to become the largest nonprofit in America, helping low-income and working-class families file for bankruptcy. And the reason that we were able to achieve this feat was because we focused on user needs, and we got to know the community we were trying to serve at a deep level, but also tried to think creatively about how to help people who weren't currently being served by the existing options available, whether it was private solo lawyers or legal aid organizations that had waiting lists and weren't able to serve the community. So that's what has led us to grow. And I think it's a great story of thinking creatively about alternatives to existing traditional delivery models. And one thing that benefited us was that bankruptcy was a federal area of the law and that it was non-adversarial. Simple Chapter 7 bankruptcies, you submit your forms to the court, then you meet about a month later with the trustee who oversees your case, but there's not some creditor that shows up against you at that meeting. So the combination of bankruptcy being non-adversarial and federal allowed us to scale across the country, and has led to us being able to become the largest nonprofit in America for bankruptcy. So happy to answer any questions later, but I just wanted to share that example. And my hope is that there will be many more models like Upsolve that take this unmet need and think creatively about how can we scale this one-to-one assistance. And of course, we believe that if we were able to reform the existing UPL rules in America, there'd be so many opportunities to provide an additional level of assistance to people who we're currently not able to serve because they have more complicated cases and do require more handholding, but that's handholding that we can't currently provide because of the existing regulatory framework. So we do believe that there'd be so many opportunities if we were able to reform current UPL rules in America to expand and help even more people access bankruptcy and other civil legal services.
Thanks a lot, Rohan. Sarah, over to you.
Hi, my name is Sarah Bové, and I am a limited license legal technician. Usually we're just called legal technicians or triple Ts because it's a mouthful. And I have a family law practice. I am not an attorney, but I practice only in the area of family law, which is divorces, legal separations, parenting plans, custody issues, third-party parentage currently, and child support modifications. And the license came about because there was a civil legal needs study here in Washington that found that the vast majority of even moderate income people, and moderate income people at the time was defined as, just under $95,000 a year with a family of 4. So that's most of our Washingtonian neighbors here. They can't afford an attorney for their family law needs. And so the state here was quite innovative and developed a license, came up with education and requirements. That license, I'm a member of our bar association, our state bar association. I have regulated, people can file a complaint against my license. I'm required to have malpractice insurance. And so most of the time when people come to my firm with my partner and I, my law partner and I, they don't see a huge difference. We explain to them the difference between an attorney and a triple LT, but for most of what they're going to go through, for most of what they're doing, they don't experience much of a difference at all. We are allowed now under our license to attend hearings with our clients. Our clients have to give their own legal argument, which we will often write for them and explain to them how to respond. But we can attend that hearing, we can stand there with them after the court gives its ruling. We go out in the hallway, we work with opposing counsel or the other party, we will draft up the order, we give that back to the judge, go back on the record if need be, get that clarified and help people move through. And I know that oftentimes people think about the idea of a non-attorney and they're assuming that that means that some usually people use the term secretary, is just filling out forms. And that's not the heart of what our work is. The heart of our work is, what did the legislature write as far as how a parenting plan should be thought about in court? And then what are the facts of our clients that need to be brought to that judicial officer so that judicial officer can make the decision based on the facts in the declaration, maybe some exhibits that we've been able to back up maybe some third-party declarations, so that that court can actually implement what it is the legislature wanted the court to do. But if people can't figure out or have difficulty getting their facts in front of that judicial officer, then that what the legislature wrote doesn't mean anything. Nothing at all. It means that the other side can just power through, and it creates quite an injustice. And I think over my last 4 years of practice, what I've loved the most is seeing our system actually work. The way that the court looks through these facts and looks through these issues, they can come up with some great results, but only if they can hear both sides. And I've been on cases where my clients have me and the other person has nothing. And they don't have much of a chance if they don't have the ability to get that fact in front of the judicial officer. There are some cutoffs for our license. We don't do trials. We only are motions practice up into the point of trial. And there's some other limitations. If people have questions about that, I'm really, really glad to talk about that, to talk about those limitations and kind of the nuts and bolts. I know there's some other presentations out there that talk about that, but I really wanted to talk first off about what does that practice look like? Is it scary to have a non-JD out there consulting with clients, taking down their stories, drafting their pleadings, filing them, serving them, attending with court? And I would say most of the time, you're really not going to see much of a difference, except for when you're in that hearing and the client themselves is giving their oral argument for a motion. My background in education, I have a BS from the University of Utah in political science. And then I had some paralegal courses that I needed to take in order to get my license. And then I had 3 classes that I took from the University of Washington School of Law, which is completely focused on family law. And then I sat for a bar exam, not the full bar exam, a smaller limited license legal technician bar exam, and had the full background check that's very, very similar to what it is the attorneys here in Washington get. The license means a tremendous amount to me. It's a promise that it matters. It's a promise that people with disabilities who may not be able to have the executive functioning skills, right, to be able to get their facts in front of the court, It's a pathway for everyone, for the promise that our legal system actually means something for everyone. That's what this license means to me, and it's so heartwarming to know that other states are adopting this, that other states see that this makes a difference, and that there are things that we can actually do to open this up, right? And we all know that paralegals and law offices, they do all the heavy lifting. We know that people who are educated and don't have a JD are doing the critical thinking. They're doing the interviews with clients. They're writing up the pleadings. They're writing the motions. You know, and all we need to do is just open that system up to allow, just like the medical system has, to allow those people who do that work to do that work in a way that's economical for everyone. And it's not a replacement for an attorneys. I know that some issues here is some worries that, is this going to replace, are people going to get less than, right? Are people going to less than? And in our practice, what I know is it actually makes attorney representation a reality. So if people do need to go to trial, and sometimes that will happen, if they do need to go to trial, it is going to be more affordable for them to do that because we've handled the case up until that. We've handled the discovery. We've handled some of that more hour intensive work well, so that if they do need to go to trial, that can be more affordable for them. And I think I'll also be happy to answer any questions about the license.
Thanks, Sarah. We have a lot of questions piling up, but I think we'll just go through the rest of the panel and then hopefully get through as many of those as possible after everybody's spoken. So Katie, over to you.
Great, thanks so much. All right, like Chris mentioned, my name is Katie Stewart. I'm a licensed clinical social worker by practice and training. I am currently the national coordinator for VA's Veterans Justice Outreach Program, and we'll talk about what that means. So I have a number of slides here today. Most of them we'll move through pretty quickly. I have them here primarily for reference, but just to speak a little bit about the mission and vision of our Veterans Justice programs. Our mission is to identify justice-involved veterans and contact them through outreach in order to facilitate access to VA services at the earliest possible point. We do this by building and maintaining partnerships between VA and key elements of the criminal justice system. And our vision is that every justice-involved veteran will have access to the care, services, and other benefits to help him or her maximize their potential for success and stability in the community, to include avoiding homelessness and ending their involvement in the justice system. So we have two programs under our Veterans Justice programs. The first of these is our Veterans Justice Outreach Program. That's the program that I work with. And then we have a Healthcare for Reentry Veterans Program, and that does similar work in the prison system. So as Chris asked me to come and talk today, speaking about what veterans' legal needs might be that we see in the field. So we have about 400 typically social workers doing this work in the field. So this could be outreach in local jails, outreach in prisons, working with local law enforcement through things like crisis intervention training, or working with veterans treatment courts. If you all are familiar with that, it is a model similar to drug courts, but specifically for veterans. And as our social workers work in these settings, they see a number of legal needs for veterans that are often beyond their criminal justice involvement. So we're going to talk about those needs. We're going to talk about kind of what VA is doing now, and then what needs are currently left unmet. So VA does something called a challenge survey every year. It is not a survey specifically of legal needs. It is a survey of needs for homeless veterans, completed by veterans, VA staff, and other stakeholders. But within this context of needs of homeless veterans, we regularly see legal needs rise to the top. So of the top 10 unmet needs from last year's challenge survey, you'll see that 5 of those are legal needs: eviction foreclosure issues, child support and family law, outstanding warrants and fines, restoring driver's licenses. And where this says discharge upgrades, that's referring specifically to an individual's discharge from the military. because oftentimes dependent upon their discharge, whether that be other than honorable, dishonorable, bad conduct, those particular discharges can have implications on their benefits, healthcare and financial compensation. So that is oftentimes a legal process to address that. And I'll speak from my experience. So now I'm in this national coordinator position, but I worked in the field as one of our Veterans Justice Outreach Specialists for several years. And Sarah, to your point, family law so often came up as a very significant unmet need that we really had no resource to refer anyone to. So VA, we'll talk a little bit more about this, but we, and part of our effort to respond to this, VA can't fund legal services. There are some minor exceptions to that, but across the board, VA can't fund legal services. But we have worked with local legal aid and nonprofit providers where VA can provide some space in our facilities for legal providers to come in and provide some services. So this year, there was an article published about interviews and surveys that were done with those providers to identify the needs of the veterans coming to them in these clinics. So you can see those on your screen, similar to those that were identified through the challenge survey. Some questions to these same providers was included. Does your clinic have the capacity to serve all or most of veterans seeking legal services? You'll see that 61% of those providers said no. And the most frequently cited reason was lack of funding. So you'll see that even in this partnership, there's still a significant amount of unmet need. So the question of, why does a healthcare organization care about legal needs? Why is this relevant to us? So we know that the identification of legal needs affects health outcomes. It can affect a veteran's mental health. It can affect how they may cope with some of these stressors, whether that be with substance use and other concerns. And we know that we can be more efficient and productive with our healthcare services if an individual's legal needs are met. And it's also consistent with VA's priorities. You can see that as well. And we know that in certain areas, there's not always good accessibility of civil legal aid, and we know that there's an increasing demand for it among veterans. So there are a few things that VA has done in response. I just spoke about one of these is the pro bono legal clinics. We have about 170 of those operating in VAs across the country right now. The VA also has a directive to our staff to compile a list of local nonprofits, legal service providers, legal aid that may be able to help a veteran if they share about a legal need. So our staff at our facilities compile those lists and provide that information to veterans. It's a small drop in the pond, but a part of what we can do to help bridge that gap. So VA also is working towards medical legal partnerships. So this is more than just a legal clinic. This is where there is enhanced collaboration between the legal partner and the healthcare team. So we have about 30 of these at VAs across the country. So again, just speaking to VA's response to this need, each year the Veterans Health Administration, for the past several years, has put forward a legislative proposal seeking to add a section to the code that would authorize the VA to enter into agreements, make grants to provide legal services. This is not, become law yet at this point, but it has been picked up in several pieces of legislation that are in different parts of the process that you see listed here as well. So as Chris and I were talking about veterans' needs and what legal needs may be able to be addressed by non-lawyers, it brought to mind the SOAR process. So this is not owned by the VA in any way. This is sponsored through SAMHSA in collaboration with the Social Security Administration, but it is a model that helps individuals apply for Social Security disability benefits through a process of training and certifying a case manager that walks a veteran through this process. So this is something that came to mind as Chris and I were talking that maybe traditionally would have been done by a lawyer, but through this collaboration between SAMHSA and the Social Security Administration, veterans have access to this through a case manager level provider. So you'll see through the slide here, this is an incredibly effective program in terms of individuals that are approved for their Social Security and disability. And then this slide speaks to VA's partnership with SOAR. So the Veterans Health Administration has affirmed the importance of using the SOAR model of our staff, often in our homeless programs, taking the training and assisting veterans with this process. And SOAR has collaborated with the VA to create 2 different tools to work with staff in our homeless programs to really equip them to support them in this process. So I hope you were able to hear about some of our experiences and better understand the needs of the veterans that we serve, some of VA's efforts to help bridge that gap, and unfortunately where there really remains some significant need. Thank you.
Thanks so much, Katie. And last but not least, over to you, Michael.
Hi, everyone. How are you? I'm just going to get my slides up real quick. So I work at the Brentwood Public Library as the head of reference and patron services. What that means is basically every adult that comes to the building who needs help with something, I need to figure out how to help them and get my staff to do it. So just to give you an idea of what we do overall is that we fill the gap. Our patron base is multinational from all around the world, with usually very complicated family and very complex family issues and very complex immigration issues. So just to give you an example, a gentleman comes from Southeast Asia to get married. He gets married, and then the family that his wife's family he's now staying with no longer wants him to stay there and is depriving him of his official documents. And all of a sudden now he's trying to apply for a visa without his marriage certificate or any of his other information. Or very commonly, a international divorce is a very common issue, but it's also usually tied up with an immigration issue and a domestic violence issue. So you're talking about people trying to get mixed immigration status in each family, and they're just trying to work it out. So that's just like a tip of the iceberg for the legal issues. But in general, we also have issues with food scarcity, with the access to mental health assistance, and to access to instructions on how to do government benefits. So whenever possible, we fill that gap by partnering with other organizations. My librarians are not trying to become lawyers or social workers or trying to do any of that work. We're just trying to get people connected with the information that they need. So every day, literally every day, we assist people with unemployment. So, that has been especially severe during the epidemic. Before the epidemic, we did it in person. Once we had to close, we started doing it over the phone and through GoToMeeting. Once a week, we had lawyers come in that had very light screening, and those lawyers would basically give a 30-minute consultation, and they'd be from our nonprofit partners. So they come from legal aid or they come from legal nonprofits, and they'd assist our patrons to the best of their ability in those 30 minutes, and maybe refer them to somebody who could do more detailed representation. We contract Family Service League to supply us as a social worker for twice a week. So it goes through their malpractice, their credentials, but they work out of our building, and we're helping pay for that person's salary so that we can have that service. Healthcare navigators, SNAP guidance, Medicare, mobile food pantry. If there's a crisis in our community, it's our job to try to do what we can to find partners who can help us fix that. And that hasn't changed. Once COVID came, it just moved mostly virtual. The only thing that we're still doing physically is the mobile food pantry, because obviously, you can't give people food through a computer, so that's life. So just give you an idea what that looks like. On the upper right-hand side, mobile food pantry, that was a day in the summer where we had over 400 people, 200 plus families coming in for food. There was over 10 pallets, and there was not enough volunteers, so I had my staff out there sweating bullets in the middle of the heat, helping hand out food, because that was our only choice. The small meeting rooms on the left, that's where we generally had our lawyers meet with our patrons. Right now we're using them for proctoring, online interviews, virtual court appearances, and we're working on how to figure out how to get the lawyers back in the building. We might do like where the lawyers are virtual, the person's sitting in the room. We'll figure it out. We'll get there. And then at the bottom is a job fair that we used to run twice a year in the building. Obviously, it's not going to happen like that anymore because there's probably, it doesn't look like it, but there's probably like 200 people in that room if you like really were to count it up. We already hosted one virtually. We had over 50 companies, I think over 100 participants. So we've already got that up and running virtually. But this is just to give you an idea of what we're doing. Now, the challenges for us is this. Patrons will come to us without warning and without understanding that there is a legal barrier, looking for help. So they will walk up to the desk and they will hand me their legal paperwork, like literally hand me the packet from the court and say, I need you to help me fill this out. This has happened 3 times in the last 4 weeks. This is not like an uncommon occurrence. This is a fairly common occurrence. And that's like the easier thing to handle. Because when it is someone who's like your mom's age, who's on the verge of tears, talking about their divorce and how they're going to lose their house, and they just walk up to the desk and they ask you for help, and you don't become a librarian because you want to make money. That's not the motivation. You usually do it to help people. So when you're engaging with that person, it's very difficult to suddenly say, oh, I can't help you. That's unlawful practice of law. Can't do this. So you find yourself like standing next to them, looking down and like trying to kind of coach them through it without coaching them through it. And the entire time saying, I'm not a lawyer and I could help you find a lawyer if you'll let me help you find, oh, okay, no, that's what you put there. Yeah, that's right. So it's like the entire process, the entire time. And we have policies in place that say librarians cannot fill out forms. Librarians cannot locate legal forms. Even if like we know what we should be giving the person, we're not supposed to do it. And even then, there's like a weird gray area. So, part of our Access to Justice initiative is we've been working with New York State Family Court. New York State Family Court has online DIY forms for people to navigate the legal system so that they can fill it out themselves. And it would be like, in their mind, it's easy peasy. And they just print it out and bring it to court. The problem with that is we're dealing with a major digital divide. We have patrons who come from places that literally never had internet. So even if they're my age or younger, they've never had access to a desktop. Like their idea of the internet is their phone, and you can't fill out those forms on your phone. Or you have people who are unfortunately illiterate. Or you have people who never learned how to use a computer, or they learned how to use a computer for their job, but they never learned beyond those basic skills they needed. So all of a sudden we're filling out the DIY legal forms, which I don't know if that's illegal or not. Like I couldn't tell you. Like we're just kind of telling them what to put in and helping them best we can. And just trying to make sure that people are able to get the help they need. And a lot of times people have a limited understanding of what they have to do. I think Sarah mentioned, people with disabilities. Oftentimes, people have invisible disabilities that lead to them getting very frustrated because they can't do the thing that everyone expects them to do. And it's kind of unfair for us to put that on them based off their physical perception, but that's just the reality we deal with every day. People have early onset Alzheimer's, they come into the library and they need help, and they're like 50. Or they're 18 years old and they just left their house and they have a learning disability and they've never before had to do anything on their own. And all of a sudden they're trying to get the paperwork from their abusive dad who's in Florida and they're in New York. Like these are real examples. That's the reason I'm able to rattle them off so quickly, is that these are all things I've had to deal with personally. And I'm one person. There's 700 librarians in Suffolk County. So that's a lot of really crazy human stuff that we have to deal with. And I'm just one guy. And it's not like I knew these people beforehand. They just walked up and I happened to be sitting there. Like, that's it. So what we need are solutions that will protect us, that will allow us to do the most basic of things in the legal field, to then hand them off to a lawyer who we believe they should be represented by. And we believe lawyers have that role, but we need to be able to get them the paperwork and get them to do the paperwork where they can qualify for free legal help. Or we need to be able to work with the legal partner to get them the paperwork they need and show them how to fill it out. Just sit there and say, hey, you know, when they're asking you for the deed, that's only if you own a house. Do you own a house? No? Okay, yes? All right, do you know what your tax map number is? And then walk them through that process of acquiring a new deed, your tax map number. Again, that happened in the last 3 weeks. This is not far-fetched stuff. This all has happened recently. So we need those legal protections that allow us to do that. We also need to get more training for librarians from legal partners on how to do a proper referral. Toro Law did a training for us a couple years ago, and it was fantastic. It really helped a lot of us figure out how we do this on the desk. And then the last thing we need is a real database of nonprofit legal providers that doesn't require us to pay $3,000 to $4,000 to access. It's just something that, you know, exists, that we could go on and just look up, like, oh, hey, who's in New York and who does these things and what are their restrictions? So I could hit search and bring up a list of people and be like, all right, I'm going to try to get you connected with one of these people, but let's figure out what we have to do first. And then maybe I can have the forms ready and just kind of do it rather than worry about whether or not I'm going to get sued or fired. Sorry, guys, that's all I got.
Thanks, Michael. Judging from the reaction in chat, it seems like a lot of people had similar reactions to mine listening to the four of you speak, which is a complex mixture of feeling really inspired by what you all are doing and grateful to hear from you, and also sort of frustrated and annoyed to hear about the kinds of barriers that are standing in your way of doing more, which is a good segue into the questions that we have so far. I've got several lined up, some for some of you as individuals and at least one for all of you, two for all of you as a group. So I'm going to start running through those in the order that they came in, more or less. In the meantime, I think we'll still have time to get through at least a few more beyond the ones that we have. So if anybody in the audience does have any questions and you haven't put them in yet, please do so, and I'll make sure to ask them. Right, so starting off with you, Rohan, we had two people ask. Towards the end of your talk, you sort of mentioned that you really hoped that rules could be reformed in a way that would allow you to do more. So we had pretty much the same question come in from two different people in the audience, just asking you if you could elaborate a bit, give an example of a rule or how the rules writ large actually do prevent you from doing things that you wish you could do.
Yeah, I'll talk about three of them. One of them is unbundling of legal services for bankruptcy is not permitted. So a lawyer cannot ask for some fee to review the forms and then give the forms to somebody to then file on their own pro se. And I could see there being a lot of demand for people who aren't totally comfortable 100% on their own, wanting to use our software, but then wanting to go to a lawyer, get the forms reviewed by a local lawyer, and then being able to have them sign off and ask any questions for their own peace of mind, and then filing those forms on their own. So that's one, is unbundling within bankruptcy itself not being permitted. A second is, of course, some states have started to allow folks like Sarah, who have a specialty within one specific area of the law, to provide more handholding throughout the process for an individual. So I would love to see all states adopt those types of rules to allow folks like Sarah, whether it's with family law or within bankruptcy, to provide specialized more handholding to individuals who need help. And then a third is for federal areas of the law where there are pretty minimal state-by-state differences. We see that within bankruptcy, that it'd be easier for somebody to practice across state lines. And we see the movement for diploma privilege, of course, and that's something that I'm really excited about. I hope that it's adopted more widely, and that I could totally see that being beneficial in bankruptcy, or something like fair credit reporting or fair debt collection, where there are very minimal state-by-state differences, and they are federal areas of the law.
And a related question, Rohan, is if you had to choose one of those three things to tackle first, which would it be?
So I'm excited about all three, and I think there's momentum behind all three. So I'm particularly excited, of course, about removing the monopoly that lawyers have on the law. So I think the UPL reform to allow non-lawyer professionals to provide assistance would be exciting. My other hope is that lawyers themselves, I mean, look, we're all on Zoom right now. People are acquiring new clients on Zoom. So for federal areas of the law, I would hope that it would be easier for somebody to provide assistance across state lines when appropriate, because it's not a whole lot different from somebody sitting in their own state and providing assistance to somebody.
The next question, Rohan, came in for you, but I'm going to repurpose it slightly because I think it's of relevance to everybody on the panel. So as it was directed at you in particular, Rohan, the question is, have you thought about the challenge of reaching people who own homes and therefore, at least in theory, have some kind of equity? Legal services generally face the challenge of how to meet the needs of families who aren't poor enough, quote unquote, to qualify, even though they are in desperate straits. So you can answer that, but I would also be interested, Katie, Sarah, and Michael, if any of you have thoughts about kind of this larger issue where often the conversation we're having tends, for very good and understandable reasons, to focus on the poorest of the poor, people who at least in theory ought to qualify for some kind of free legal assistance where it exists. But how do the issues that we're talking about, as you see them, relate to people who maybe aren't poor enough to qualify for that kind of assistance? How do those needs differ, and how do your thoughts on how to extend help to people in those situations differ? But Rohan, why don't you go first, since it was originally directed at you?
Yeah, I mean, I think that is the perfect example of where self-service software presents some risks that if you were allowed to go and get help from a specialized professional who was lower cost than a lawyer, you benefit from, but somebody right now is lost because self-service software has risks involved and a lawyer is out of touch. So I would love to find a way of providing those folks with some sort of human reassurance, so that they don't risk losing their home when they're filing for bankruptcy. And obviously that's the benefit of softwares, can do a lot of the data collection to lower the cost for that eventual professional who uses their legal discretion. But that sort of human software symbiosis is not permitted within the current regulatory framework. And I could see that meeting a unmet need within legal services.
Thanks. Michael or Sarah or Katie, do any of you have any thoughts on that?
I do. It's kind of that spot is exactly where I think the Triple license was designed for, especially, right? It's that moderate income bracket of people. And you know, I myself, when I had to get 3,000 supervised hours before I was able to get my license. And I did some of that with the Moderate Means program, which also works with another program to give, you know, connect people of low and moderate income with attorneys. And a lot of people would be right at that cusp where if they did own a large piece of property, but that's all they had. They had that and Social Security, right? Or some other issue. And I think the key is unbundling, right? I think that really is where it starts. And we do that in my own practice. For instance, I have a limit. I can only advise a client if the equity in their home is under $250,000 right now. It's 2 times the homestead exemption. And so if a client comes in and they happen to have more equity than that, but can't afford an attorney, you know, what we do is we bifurcate the issue and we go, okay, we're going to help you write out what it is you think you want. And we're going to have to write out in a memo what it is that you have exactly in terms that an attorney can quickly understand. And we're going to give that to you. And then we have a list of attorneys where in our state, we're allowed to have non-exclusive reciprocal referral agreements. We have a list of attorneys who refer to us and we refer back. You can go to any attorney you want, or you can go to one of these, really doesn't matter. Get the written instructions on what it is we're going to do with that home, bring it back to me, and we can finish the process. There's so many opportunities in family law, and I suspect in other areas of law, where you just pull it apart and make sure that the right person's handling the right part of the job.
And one thing I'd add is, and this is great, Sarah, is like as a community, I think it's our job to communicate just how much these alternative models don't take away any sort of business, either from the legal aid community or from the private bar, but rather supplement and help promote access for an unserved market that doesn't have the money to afford private attorneys, but is actually higher income than what legal aid traditionally has as an income cutoff.
So what we did was we had in part of our Access Justice committee, we created this thing called the Community Legal Help Project. And we had lawyers come in who were either donating time or part of a legal nonprofit or legal aid, who we would only screen them very lightly for eligibility, meaning that as long as somebody didn't have like millions of dollars in assets and was looking for a really complicated legal case, they could sit down with a lawyer for a half an hour and get that kind of guidance that they might need if they just need help filling out that the bankruptcy paperwork, whatever, just like real quick, find out what they have to do. Like that was really what that was designed for. A lot of those people ended up getting representation from our legal partners, but it's kind of like 2 pieces of a puzzle, where like the first half was getting them in a room with somebody who knew what they were talking about, and they were all lawyers. And then the second half of that was, well, can that person help them more? Which then depended on the individual grant funding of the different organizations. But we were able to kind of walk them through that then, versus the person trying to figure it out. So you would have, you know, we work with National Suffolk Law Services, who are great. And they did a lot of the screening for us, and they would say, okay, you know, you don't qualify for help through us, but you qualify from help from legal aid or from this other organization. And they really handled all that. So the patron didn't really need to think about it. They came in, they met with a lawyer, and then they got handed off to either someone who could help them, or they got the help they needed, and that was it. So as far as the patron was concerned, they walked in and spoke to a lawyer on Tuesday afternoon.
Thanks. Sarah, I'm going to put a question to you that came up, and then the next question is a complicated one. So the rest of you guys might want to check it out in the chat. It's the one from Becky Sandifer about kind of opposition to change from various quarters, which I'll read when we get to it. But Sarah, I had one person in the audience was asking if you could elaborate a bit more on what, if any, other areas triple LTs are allowed to practice in, which I know has been sort of a fraught question. I think these 2 things go together reasonably well. So I'm going to put another question to you as well at the same time, which is somebody asked you, I want to just capture their language right. And the audience may not know the background here, or at least not all of the audience, so you might want to speak to it a bit. But The question is whether you're discouraged by the step back that Washington State took. And are you seeing a push to revisit it and get it back on track?
So for the first question about areas in which Ts can practice, so I will say originally the license only allowed legal technicians to handle minor parenting plan modifications up to a limit. We were not allowed to do major parenting plan modifications, and we are not allowed to do third-party custody actions, which in some states looks a lot more like a dependency. So that's where like grandma has grandchild, mom and dad are unable to care because they have addiction or some other issue. And so it's a legal action so that grandma can have custody. That's third party custody here in Washington. And it was expanded in order to allow legal technicians to handle parenting plan, minor parenting plan modifications, major parenting plan modifications up until the adequate cause decision, and then third-party custody up to the adequate cause decision, unless it's by default or unless it's by agreement. So there's a lot in my rule to practice. There's a lot of carve-outs of you can do this except that, and so to be pretty mindful of those restrictions where it's at. So it was expanded. Unfortunately, this license in our state is highly political, and it's political for, I think, a few different reasons. And I think there is a constant push forward of this is a great solution. This is working. People are getting the help they need through this license. And then there's another push of you're not a full attorney, you're a half lawyer. These are don't have the front desk person practice law. And well, who's going to pay for this? Who's going to pay for the structure of the license? Who's going to, you're going to have enough bar dues from the number of people licensed in order to cover the administrative costs for a license? So you've got a lot of push and pull, and I think it's been that way since inception, since before it was even there. And all we're seeing is just a rippling of that back and forth of the different people getting in different positions of influence. And I don't suspect it will stop. I think it's going to be very similar to how nurse practitioners, there was a lot of heavy resistance because they were not MDs. And now we don't think very much at all. If most of us go into a nurse practitioner, we know that they understand what their limits are. We don't even ask them, we trust them. And I think eventually we will get there, and it's just how quickly we can kind of move to that place. So that's the area of practice, and kind of, am I discouraged? I was so excited to see our state here in Washington make such a bold move, and to do so by writing it up as a rule. And I know when I was getting my education, we had the law school professors say, there's some people who are saying you could possibly, what if they change their mind? What if they change their mind? And what everyone was saying back to us was, if they were going to change their mind, they wouldn't have written it as a rule. They don't usually undo rules, right? And it was shocking to hear that after a very short meeting that was about something else, they had a vote out of nowhere in order to sunset the program. Now, lots of things have happened since that vote, that decision. There have been changes to the license. There's been major improvements to the license. They've lowered the amount of hours people have to get. They've expanded, so now Ts, when they're in a firm, because they can own firms with attorneys, Ts can sign trust checks just like an attorney can. So we've had improvements to the license, and in my gut, I say, I don't think we're going to continue to improve this license if we're really going to abandon this idea. Not really. And so that's where I'm at. I'm disappointed, but ever the optimist that, the right thing will happen, because there's a tremendous unmet need. And this is a great way to take a huge step forward in that. And I don't think it's going to go away, especially with other states adopting it.
So I think that answer is a really excellent segue into the next question, which is for all of you on the panel, although you may have already said everything you want to say on it, Sarah. I don't know. This is from Becky Sandifer, who was our keynote speaker earlier in the day, and she asks all of you this. At the 10,000 feet level, we often speak in the abstract about different kinds of resistance to the types of work you're doing that comes from big constituencies, for example, lawyers. Do you run into this day to day, whether from other types of providers, from court staff, from parties on the other side, from anyone? Understanding this would be useful in thinking about strategies to move non-lawyer work forward and about how to support folks in doing this work.
I can actually chime in with a counterintuitive observation from our work from the last 4 years, which is the two other stakeholders besides lawyers who we interact with, and we actually don't really interact with lawyers, are court staff and trustees within the bankruptcy program. And counterintuitively, they've actually been excited that Upsolve exists, because when they see a perfectly prepared petition for a pro se litigant, they're excited they don't have to do this extra work of telling them that there's these deficiencies or telling them to go and make amendments. So we actually have reduced the work for court staff and trustees. And from a strategic perspective, I think talking about these alternatives to lawyers, so talking about these paralegal programs, these LLT programs as an alternative to pro se individuals interacting with the courts, I think is particularly effective. So saying, hey, if we didn't exist, you would have a bunch of pro se individuals who actually had no preparation, and then that would slow down the courts and cost the courts a lot of money. That's why we should consider these alternative delivery models, I think is effective strategy for pushing this type of work.
Okay. The next question is also directed at all of you, which is whether any of you have partnered with your local public, county or otherwise, law library.
Yeah, I mean, we call them when we need legal information that we don't have in the building. It's pretty standard practice for us just to pick up the phone and give them a call. You know, it's just that the last thing you want to do when you have somebody in front of you who's already in crisis is send them someplace else. So a lot of times that phone call is the most we can really do in that moment to partner with them, is because it's like, I have no idea what to even do with this. What do I do? So we'll call them ourselves, explain the situation, and we'll get help that way.
About 2 years ago, my law partner and I partnered with King County Law Library to put on a series of family law classes where we focused on really talking through what are the things that a judicial officer can make a decision on, right? What's the kind of relief that you can get? And what are things that are kind of, in the most part, generally going to be a personal decision? Because some of that about what can I ask for, even what kind of relief can I even get, is, you know, unless you understand the terminology, unless you have a really good understanding of, you know, how government works on this kind of scale and a personal scale like this, it's going to be difficult to know, right? Otherwise, most people's understanding of divorce are, you know, what people have heard from other people or what they see on TV, right? And so we partnered with them on a series of classes to talk about that. I think that's effective, and that's things that attorneys do as well.
We have 3 full-time people at Upsolve responsible for outreach, and one of the stakeholders that they reach out to is law libraries to list Upsolve on their websites.
Michael, this one is directed at you. So the person who put the question says that they are an immigration paralegal working for a nonprofit organization. And the question is, when a nonprofit legal aid organization approaches a library for partnership, what should be the priorities?
Allowing patrons as immediate access as possible to you. So, like, jokingly, like, good luck getting out of the building without getting put to work, because every single day we're handing out applications for naturalization and dealing with questions about that, and referring to lawyers. But really, the power of being physically present or being even available by phone immediately can't be second guessed. So if I have a patron in front of me who's in the middle of a legal issue, they don't want to necessarily hear they're going to get called back tomorrow. They want to, if they can, they want to talk to somebody right away, which I know is not possible. I'm not saying that everyone should be available 9 to 9 like we are, that everyone has that sort of availability. But even just saying to them, Tuesdays from 1 to 8 is when you can call and talk to them directly, has a huge impact on the ability of patrons to feel comfortable talking to you. And that is one of the main things that we consider when we're going to partner with somebody, is are our patrons going to feel comfortable being referred to you? Because a lot of times they don't. They come to us because they feel comfortable with us. I mean, so it's a matter of making sure that we feel comfortable with you and making sure that we know that our patrons will feel comfortable with you. It always helps if you start with upfront. I work for a nonprofit, like a 501c3, because we have a lot of people who come into libraries, especially in the financial industry, who come in saying they're a nonprofit, and then I have to kind of investigate who these people really are. And a lot of times they're not really nonprofit. They're like an outreach officer from some corporation, and there's some questionable stuff going on. So that's another part of my job, is vetting those people and being like, is this person for real? Like, what's their deal? Are they lying to me? They're probably lying to me. So being clear about who you are, being clear about what your legal status is in terms of like your ability to provide services, whether or not you are getting government grant funded money, what your eligibility criteria might be, and then just making sure that we're comfortable with you, knowing that if we have a set time or a set way of making sure the patrons can contact you in a way that's easy for them. And that includes having staff that are bilingual or trilingual or, other ways of providing access, even for patrons who have disabilities.
Thanks. So I'm sitting here having talked to each of you before, thinking about what we haven't heard enough about. Katie, we've talked a couple of times, and a big part of our conversation has been about kind of your life before taking up the role you're sitting in now, when you were working in a frontline role in rural areas and the kind of day-to-day encounters you had with the unmet legal needs of the vets who you served. And I think it would be great if you wouldn't mind just to take a couple of minutes. You did a really good job of unpacking the larger truth of that your own experience points to through the challenge survey and stuff. But I think it would be great just to talk in a more micro way about kind of immediate human reality that some of your people and you yourself, especially in relatively remote or rural areas, actually come up against.
Sure. Yeah. Thanks so much. So before I am in this DC-based role, I was a Veterans Justice Outreach Specialist in Western North Carolina. So it's a beautiful part of the country, and there's an urban center there, but for that portion of the state, it's primarily rural, and the access to legal services is pretty limited. Working as a social worker in that community, if there was an issue around eviction or tenancy law, that was usually pretty well met. But really civil legal issues outside of that, there were incredibly limited resources. So oftentimes we would have people coming and needing assistance with child support. So in my role, I routinely did jail outreach, met with veterans that were in the local county detention centers, and often met with veterans that were there for child support issues. So, they're stuck in this cycle of they can't pay their child support. So they end up in jail, and now they've lost their job because they're in jail. We know that incarceration is a really significant indicator of future homelessness for any adult male. So perhaps they've become homeless during this time they've become incarcerated. So their life has been disrupted in every possible way. So, by the time they eventually are able to get out, they're in a worse position to be able to pay their child support. And they don't know how to go about doing a child support modification. And that's not something I'm trained or have the resources to do. And we would even have situations. So one of VA's programs to help meet the needs of homeless veterans is a partnership between the VA and HUD, Housing and Urban Development. HUD provides a Section 8 voucher, VA provides case management supports. But within that program, veterans have to be able to pay 30 to 40% of their income towards their rent. And we would have veterans that were eligible for the program in every other way, but their child support obligation took up so much of their income that they couldn't meet that rent portion. So we weren't able to house this homeless veteran in this program because their child support obligation was so much. The same thing around, visitation for families. They would talk about this, especially, as related to kind of a mental health diagnosis or mental health treatment. They're especially around other issues of the law, like getting a driver's license reinstated. If you're in a rural community when you don't have access to public transportation, having a driver's license or not really can mean having a job or not, being housed or not, getting an education or not. And oftentimes, the veterans I would work with would keep driving because you have to keep getting to places, and then would of course continue to have future encounters with law enforcement for driving without a license. So that's a cycle I would often see people in. All of those issues that we talked about kind of from that upper view, I would see people live out in their day-to-day experience. So anywhere from that family law to driver's licenses, or, having fees and fines to the court that took up so much of your income, just a number of these different stressors that affect an individual's health outcomes. So we talk about, why is this important to a healthcare agency? Because we know these issues affect their health outcomes as well.
Thanks. We've reached the end of the list of questions that we had from the audience. If anybody has one that you want to get in, please feel free to now. Otherwise, I'm going to ask one more question. You don't all have to answer it if you don't want to. And then just ask each of you if there's anything that you'd like to say in closing before we turn it back over to the organizers for a few last words. But my question is just, for any of you, is there one thing or a handful of things that really sticks out to you as work that you can't do or you're really uneasy about doing under the existing rules, where you'd really just like to see the needle moved enough to empower you to do it without being afraid of the rules, without, wondering whether it's legal or whether it could cause trouble?
For me, it's filling out forms and having, I mentioned to you in the past, almost a good Samaritan rule in terms of filling out forms. I don't want to replace a lawyer. I still want a lawyer to check the work that I did, but I don't want somebody to walk away feeling like nobody's going to help them and them never even pursuing help from a lawyer. So if there was a way for us to legally help people fill out the forms that they're asking us to fill out anyway, that would make it much easier for us to help people. And right now, a lot of these legal questions I just do myself, so my staff doesn't have to absorb that risk. But that means I'm absorbing that risk. So, I have to really be careful with what I do and how I do it and know where the lines are. And, I got my master's in library science. That's primarily on finding and organizing information, not on the law. So, ultimately I would love it if we just got to a scenario in this country where I could help somebody fill something out and they could have, maybe a half an hour to an hour with a lawyer to have the work checked, and then they can go take care of themselves in court versus them taking a lawyer on retainer and going broke. That's basically it.
Yeah.
I have to answer. I mean, I would love for lawyers to be able to provide in federal areas of the law legal advice across the entire country. I think that would allow folks like us in immigration, Social Security, especially non-adversarial areas of the law, the ability to help people so much more.
All right, we do have one more that just came in, so I will ask it. And then that might take us right up against time. This is to all of you. You can see it in the chat there, but for those in the audience who can't see the chat, can any of you speak more to success you've had getting courts and judges more open to progressive approaches? Some changes could be made in the courts without changing the laws. Rohan noted that helping pro se is helping court administration, for example. But many courts and judges are suspicious and inhospitable. How do we make them better allies? Not an easy question.
I think you do it by proof of concept, right? And I think that's how I see, and I know my law partner sees the work in our firm, right? We are demonstrating, in the counties in which we practice, that we do good work, that our clients get fair and reasonable outcomes given the facts that they have, right? And that we took the appropriate professional care throughout the process to make sure they got all the way through. And I remember my first hearing that I had, where we were actually allowed to practicing for a little while, but the rules had changed and they had finally allowed us to go in. And so I went with my client, and it just so happened that my mentor attorney, right, who had supervised my hours, had a hearing that day. And we had a pro tem at the bench who was not familiar with the license. So I had to, explain to him, here's the rule, I have a copy of the rule, I'm allowed to be here, this is why, and walk through the hearing. And I got a big thumbs up from him right after when we were leaving. And I had my mentor attorney saying, excellent job. And that was great for me. But what I was more proud about is every attorney in that room, that judicial officer, pro tem on that bench, got to have the experience that my client was there, he was well prepared, he got the relief he needed because it was fair and reasonable. And we walked out and everything continued, just as it does for other cases when people have a JD attorney. And so that's the only way I know how to do it, is just go in and do damn good work, and hopefully people will see that.
Yeah, I mean, I totally agree with Sarah. My hope is that long-term, Upsolve will not need to exist. Our goal with Upsolve is to show the courts that if you create and design a system around regular people, not a system around lawyers, you can empower people to solve their own legal problems if you provide the self-service software itself and the simplified legal forms. And that's our long-term mission, Upsolve. And in the near term, the way we hope to get there is by showing the courts and the administration, judges, that self-service tools can empower people to successfully reach the outcomes. Over 95% of people who file with Upsolve are able to get a discharge that's on par with full attorney representation. The average Upsolve user has $225 in their bank account, in their checking account. And the average cost of a bankruptcy lawyer is $1,500. So it's just so evident from the data we've collected that there needs to be an alternative to lawyers. The other thing I'll share is that 96% of people who come to Upsolve tell us that if Upsolve did not exist, they would not be able to file for bankruptcy. So through this data that we're collecting and our success at scale, I mean, 150,000 people come to Upsolve's website per month, and we've relieved over $250 million in debt. So our hope is that this track record and the success rates will be able to inform the judiciary to offer something like Upsolve themselves. And then the second thing I'll say is to start talking about access to justice not as some and UPL reform and legal simplification, not as some niche regulatory issue, but rather a fundamental issue of the American democracy, a fundamental issue of racial, social, and economic justice. And I think one of the disservice of just the discussions happening within just lawyer communities is that we haven't talked about this as a matter of civil rights. And I think it is totally a matter of civil rights. UPL reform, legal complexity, is a civil rights injustice. We've artificially limited the supply of lawyers available, and the current system guarantees that we will never have access or equal rights under the law. So by maintaining the status quo, we've guaranteed that we'll never have equal rights, and that Black and Brown communities will be underserved. And the history of America, there are so many instances of white people telling Black and Brown people what's best for them. We've done that in America in education. We've done that telling people how to live their family lives. And right now we're doing that, telling people how to access their own rights and how to solve their own legal problems. And I hope we don't make that same mistake as a country that we've made for 200 years.
All right. Unless,
Has I had one thing?
yes.
We are actually working really closely with New York State Family Court and New York State Circuit Court in Suffolk County. They have been incredibly supportive. We have direct access to the court clerks and family court in order to set up virtual appearances. When someone comes in to ask for a virtual appearance, we have the ability to get the paperwork they need directly from the court clerks. So it sounds, based off what I'm hearing from other places, it sounds like that may not be common. As a librarian, I have no idea how common that is. But a lot of this stuff has been partially motivated by their desire to make things easier for everybody else, including their DIY forms. So as much as it seems like this is stuff that just the library is doing, our Access to Justice partners have been really passionate about getting into the library and assisting people with even the minutia of the court forms. So there's gaps still because, you know, family court's just one aspect of the legal challenges our patrons face as a surrogate court. But there is, on our end, there are people within the court, high-ranking people within the court, who are willing to help, who are working towards more accessibility, and who want to use the library and other community organizations as a foothold to make people's access to justice possible. And again, I don't know how common that is in other places. I'm just saying from my personal experience, you know, Mike Williams, Warren Clark, these guys have worked really hard in working with us in order to provide that access to people. It doesn't change the fact that we need more legal protections on our end so that we can help people, but it's not that there's not an interest on their end in making that possible.
Thanks. That's really great to hear. And I think a pretty good note to end on. We are right up against the time, and I think our organizers need a couple of minutes at the end to say a few closing words. So let me just thank all four of you very much, not just for making the time to do this, but for really just being so thoughtful and candid and passionate in the way that you have helped us think through all of these issues. I think it's been a really fantastic discussion, and definitely going to get roped into similar ones in the future because you've all done it so well, perhaps unfortunately for you. With that, Liz, do you want to step in and say a few words before we all part ways?
Sure. And thank you so much, Chris, Rohan, Sarah, Katie, and Michael, for such an engaging discussion that spans so many critical policy and practice dimensions of the themes we are exploring this week. I was saying to somebody during the discussion, I feel like we could hear a virtual pin drop at times with the intense listening that was going on. And just would underline the comments from many of our participants about how powerful your perspectives are being on the front lines of this work and community needs. And also would like to thank our attendees for your excellent questions and comments throughout that really deepened this discussion. Tomorrow we will be building on these conversations with a day themed community-grown research, education, and data strategies. And I think we can preview a slide or two about those here. But these conversations tomorrow will be centering the lived experiences of those impacted by justice issues in our conversations moving forward. And that will begin with a session at 10 o'clock Pacific called Community Grown Research, Education and Data Strategies, that will be moderated by Nicole Nelson and include 3 voices on this topic that may be somewhat newer to some of us working in the civil justice space, including Liz Medicine Crow from the First Alaskans Institute, Jody Polk from the Legal Empowerment and Advocacy Hub, and Alana Greer from the Community Justice Project. And then at noon Pacific tomorrow, we will have a session moderated by Matthew Burnett from the Open Society Justice Initiative, focusing on why and how it's critical for those most impacted by injustices to be situated at the center of research. And that session will offer perspectives on 2 projects that have done that and how they've gone about that. So we hope that all of you will join us again tomorrow. And lastly, since we are almost halfway through this week, we really want to hear your feedback on the gathering and these discussions so far. So we will be doing a quick pulse check tonight in the events Slack space to get your feedback on that.